Company is the, well, I guess everybody's an appellant and everybody's an appellee. Are you ready to proceed?
Yes, Your Honor.
And are you ready to proceed?
Yes, Your Honor.
You may.
Good afternoon. April Rolen-Ogden with Lisco and Lewis on behalf of BPX. It's undisputed here that Dow claims to be a non-operating and non-participating owner, lessee owner, in a unit that is operated by BPX. In fact, Dow's mineral lease is the only basis for which they claim production or proceeds from production. So in the posture of a lessee, Dow has asserted two claims against BPX as a unit operator. First, Dow claims to be an unleased owner entitled to free gas marketing under A3 of the risk fee statute. And second, Dow claims to be entitled to the broadest possible penalty under a separate statutory reporting regime known as the well cost reporting statutes, 30:103.1 and 2. Now, on this appeal and on Dow's cross appeal, there are four legal issues presented for de novo review for which no deference is accorded to the district court. My plan with our limited time here is to identify the issue, give a brief answer, and then if time permits, talk about some of the reasons that back up that answer.
And you're not, neither party's asking to certify any question of Louisiana law.
No, Your Honor, we're not.
You're not recommending that we hold this case for Self and Johnson, the companion cases?
Well, that's a good thought. That is pending. That does directly impact the cross appeal that Dow has raised. Somewhat concerned that I guess there's a possibility with different panels that there could be different results.
You haven't recommended a hold.
I'm sorry?
You haven't recommended that we hold it.
No, Your Honor, we
Last
have not
question I had,
recommended.
threshold question is, I noticed that still pending below is your motion asserting that Dow, lacks standing.
Yes, Your Honor.
Is that Article 3 standing? They don't have an injury because they don't own the property?
The standing argument is that we don't believe they actually owned the lease interest.
But how would we reach any merits question if that weren't resolved?
Great question. Because right now it is ripe for review on a 12B6 standard.
So what allows us to assume jurisdiction if you're contesting it?
We're only contesting whether or not they have a legal right to recovery under A3 because we don't believe that they actually ever owned the lease interest. But right now, this is before this court on a 12B6 motion that was denied, where we assume for purposes of that motion that they do have, in fact, the lease interest they claim to have. And so that's why we believe it is ripe for judicial determination on a 12B6 standard. If that gets denied, then there may need to be a trial.
Why would we want to give a big advisory opinion on a complex area of Louisiana oil and gas without being certain that they actually have any interest?
Yes, Your Honor. The only answer that I have is that the 12B6 standard assumes well-pleaded facts, and it is well-pleaded that they own a lease interest.
Okay.
Thank you, Your Honor. So I would like to begin with the A3 standing issue, and that questions whether or not a leased owner, as Dow claims to be, would properly be construed as an unleased interest. And the short answer is no, and that's based on the plain language of the statute and a wealth of jurisprudence. Now, this court in Brandon versus Chesapeake said as follows: legislative intent is not the appropriate starting point for statutory interpretation. Rather, the appropriate starting point is the language of the statute itself. And the language here of A3 is clear and unambiguous. It refers to one or more unleased interests for which the party or parties entitled to market production therefrom fails to make separate arrangements. The district court here identified no ambiguity in that language. Now, in a different setting, in TDX, this court analyzed another statute that refers to unleased interests, but it had vastly different language. If you may recall, in 103.1, it says lands upon which the operator or producer has no valid oil, gas, or mineral lease. This court said, in order to determine what the bare reference to unleased interest means in 103.2, it had to examine the context. And this court considered the context to include both 103.1 and 103.2. Here, when we examine the context of 3010, we see only two references to unleased interests. The first reference is in A2EI, and that defines the term as not subject to an oil, gas, and mineral lease.
I'm going to ask a simple question. Let's
Yes.
assume you're right. Why are you paying them at all? What's the authority that compelled you to pay them sort of antecedent to deducting gross or net costs?
Well, in this factual scenario, the well is not paid out, so we haven't actually paid them anything as a matter of fact.
But the premise of your argument is that you're going to pay them the proceeds minus the post-production cost.
Well, on this issue, we're saying that we don't have to pay them proceeds because we don't believe that they have standing to claim proceeds as an unleased interest. They are a leased interest. They hold a lease from a landowner.
Okay, but what am I missing here? Is your argument or isn't your argument that you can take to market their oil, but you don't have to pay them anything? So
No.
this whole argument as to deducting costs is secondary to the fact you're not going to pay them anything.
No, let me try to clarify that, Your Honor. Our position is a lessee under Taylor versus Woodpecker, Hunt versus Batchelor. The Louisiana Supreme Court has said that a lessee is entitled to production in kind because they typically will take it, market it on their own, pay their own royalties. But in this instance, a lessee is claiming to not be entitled to production in kind, but instead proceeds under A3, which is a narrow statute that applies only to.
Well, I may be convinced that it's a narrow statute, that maybe your textual reading is correct.
Mm-hmm.
But are you or aren't you saying you can extract the oil and not pay them, the lessee, anything? So this whole issue about deducting costs is sort of an irrelevancy.
What the general rule is that we can pay them production in kind.
But you're taking it to market, so we're past that. You're not
Correct.
giving them production in kind. So why are we talking about deducting costs if you aren't going to pay them anything?
Well, it's not that I'm not going to pay them anything. They are not, as a matter of law, entitled to receive, as a non-participating owner under 3010, they're not entitled to receive any proceeds prior to 100% well payout. That's what 3010 says.
I thought, I'll just answer my own question, then you tell me if I'm wrong. I thought you were accepting and arguing that the district court was correct, that your client is in a gestor relationship with them. And by virtue of that, you do owe them proceeds if you don't pay them in kind or you don't go back to the commission and decide to partition it. But that, in fact, you will pay them proceeds. Your position here is that it's just net, it's not gross. Is that wrong?
That is correct, except the only caveat, Your Honor, is that it wouldn't be under A3.
I understand that, but it would be pursuant to a quasi-contractual relationship.
Yes, Your Honor, that's absolutely correct.
So that's the origin of why you will pay them, but you contend you can deduct the costs to take it to market.
Correct. And so, ultimately, in 1990, the Louisiana Supreme Court in Taylor versus Woodpecker expressly recognized the hole that the district court had noted in the A3 standing and reconsideration orders. And what the court said there is 3010 does not provide for owners who have no contract with the unit operator but who failed to take their share of production in kind. The exact hole that the district court correctly pointed out that our interpretation leads to has already been recognized by the Louisiana Supreme Court back in 1990. And the court explained the problem. The problem was that prior to the enactment of A3, the unit operator's implied authority to sell their gas was uncertain at best. There were claims that it could be a conversion, that you don't have the legal right to
When you say there and you point to him, you mean a lessee's or the mineral owner?
both. Great question, because there was no answer to either. And so what the Louisiana Supreme Court noted in 1990 in Taylor versus Woodpecker is that the enactment of A3 partially solved the problem. It dealt with it for unleased owners, but there was still a hole for lessees like Dow. And so what the court also said very importantly, and it's been repeated by this court in two cases that came after it, is that the relationship created by A3 between the operator and the unleased owner is significantly different. Not the same, significantly different from the relationship between the lessee and the unit operator. So our position is one of the underlying currents of the district court's order was that there was somehow intended to be a comprehensive quasi-contract. Taylor versus Woodpecker says no. It says there were holes. It says A3 was just a partial.
Well, Taylor says no statutory framework, but you're arguing that there is a comprehensive equitable framework.
Correct, under Hunt v. Batchelor just 4 years later, Your Honor.
And they say, their counter-arguments we'll hear, but I thought they're saying, so you're suggesting that the gestor relationship swallows the whole statutory regime as to lessees? And you would probably say yes.
Could you repeat that question one more time?
If you're saying that what governs relationships between the operator and a lessee is this quasi-contractual, equitable gestor relationship, that is what applies. There's no corresponding statutory regime. So they will be covered for production costs under A2, lessees will be, who have no contract with the operator. But with regard to post-production costs, that is ultimately a question of a quasi-contract. Okay. And yet, we all know what the elements of, 2292
Yes, Your
are.
Honor.
And
Yes.
their argument is this is a forced relationship. This is not an altruistic move by your client. And
I'm glad you brought that up, Your Honor, because I would like to address that. There is nothing forced here. The only thing that is forced is under A2. If my client says, I'm going to go drill a well, and the commissioner designates me as the unit operator, they're forced to ride along with that. And they can participate or they cannot participate. But under A3, assuming they're even under A3, or even if they're not under A3, there is a legal right to take in kind. Nothing forces a lessee or an unleased owner to market with the operator. They always have the right to take in kind. And what A3 tells us for unleased owners is that if they fail to take in kind and we sell the unit production, then we have to give them cash. That's what A3 means in the narrow context of unleased owners. For a lessee, if they don't take in kind, then what Hunt tells us is generally we've got to give them in-kind production, or we could give them proceeds. But there's nothing that says that
how is it to their sole benefit if you're deducting some set of costs?
So,
Doesn't the doctrine require that it be solely in?
not at all. That is not in the code article. That's not in the commentary to the code article. There was one stray reference in, I think, the Oliver case. But when you read the cases behind it, it never said sole benefit. The code article and the commentary says some benefit. However, that being said, I would point out that we don't benefit in selling their share of gas. We don't get paid an administrative fee to sell their gas. We don't get a cut of what we get from their gas. So it is completely for their benefit. We have the arrangements to sell unit production for ourselves and anyone else marketing for us. If they don't make separate arrangements, then they can ride along with us, and we have the legal right to sell their production. But that doesn't benefit BPX. And that's what all of the cases that have come under A3
You're going to reach
have
the
said.
reporting claim because you've only got a minute.
Yes. So,
I'll just ask the hard question in my
please.
mind. How can it be that you can deduct costs but not tell them what the costs are?
Great question. So if you compare 3010A3, which lays out what is undisputed to be the costs that can be deducted, you see that it does not match 103.1. 103.1 only lists 4 categories of costs that must be reported: drilling, completing, operating, and equipping. That's it. Look at 3010A2. There are 3 additional categories that are unquestionably deductible: testing, supervision, and risk charge. So that right there shows you that not everything that can be deducted under A2 must be reported under 103.1. And so the idea that a penalty would be less than what even needs to be reported, much less what is deductible, is not absurd. And what we think was absurd is how the court, in a strict construction manner, was looking for ways to imply post-production costs when it doesn't exist anywhere in 3010, 103.1, or 103.2. And I see that I'm out of time. Thank you.
Thank you, counsel. Is that Mr. Marino?
Yes, Your Honor.
You may proceed.
May it please the court, and good afternoon, Your Honors. I'm Mike Marino, and I represent the appellee cross-appellant Dow Construction, LLC. The issues before the court involve the production of natural gas, which the Louisiana Constitution specifically states is affected with the public interest. The regulation of natural gas production is delegated by the Louisiana Constitution to the Louisiana legislature and the regulatory authority it designates. As we have briefed and as thoroughly chronicled in this case, in this honorable court's decision, in TDX versus Chesapeake, as a matter of public policy to prevent waste, Louisiana enacted the concept of forced pooling to ensure the orderly development of minerals. This necessarily involves the exercise of the state's police power to usurp private property rights, which are also protected by the Louisiana Constitution, to explore for and produce minerals. In creating the statutory scheme regulating forced pooling, the legislature had to balance many competing interests: the interest of the state to produce and put its minerals into commerce, the interest of the operator, as well as the interest of those people who are forced into this unit with the operator without any choice. In creating the statutory scheme, it was a balancing act. We have to allocate costs, we have to allocate risks. We have to protect, or attempt to protect as best we can, or at least the best that the legislature could or tried to protect, all of these various competing interests. While the issues presented in this case, Your Honors, are res nova, and they're certainly important, I don't think they're particularly difficult to resolve. If you utilize a proper analysis, particularly when considering the impetus for the legislative scheme regulating forced pooling, you will see that the district court erred in finding that an operator in a forced pool can utilize this inapplicable legal theory of negotiorum gestio to expand 3010 to deduct post-production costs, which are specifically and clearly not provided as a deductible expense. The district court did correctly determine, however, that to the extent such costs can be deducted, they must necessarily be reported under 103.2 and are subject to forfeiture under 103.2. Sorry, that's to be reported under 103.1 and need to be deducted and can be forfeited under 103.2. The district court also...
I agree with their claim that you have two claims here. Is that correct? You have one claim under A3 and one under 103?
So I don't really look at A3 as being specifically dispositive of the entire issue. I think 3010A...
Making one claim that the statute doesn't allow them to deduct post-production costs. That's under 10A3. And you have a separate claim that they should forfeit even if they do get those productions by virtue of 103.1 and 2.
That's mostly accurate. Again, I don't think 10A3 is completely dispositive of the post-production cost issue. I think if you look at the statute, 3010 specifically lists...
If this prescription period for either of those two claims is delictual in 1 year, you're too late.
Absolutely, Your Honor. There's no doubt. But getting to the prescription...
Just threshold questions also. You aren't recommending that we certify anything, and you aren't recommending that we would hold for the Self-Johnson panel.
I think that's correct. I believe that the Self versus Johnson issue, while they do have some crossover, they're not completely the same issues. I don't think the arguments presented are identical. And I think that's one of the differences between the two cases. As far as certifying the matter to the Supreme Court, Your Honor, yes, we have not requested or recommended that. But the district court also correctly determined the scope of A3. BPX's arguments, Your Honors, while perhaps creative, are simply not applicable. As discussed at length in our brief, if BPX's arguments are adopted and implemented by this court, it would frustrate the entire purpose of the statutory scheme that the legislature created to govern this relatively contentious relationship you have when you force all of these folks into, or willingly, into a unit. It would also,
To put you straight, there are counter arguments. They say that just start and stop with the plain language. It says unleased interest. And you aren't an unleased interest, one, and then they say Louisiana law has said that. I think it's King v. Stroh. And on top of that, they say the whole purpose of 10A3 is because of the asymmetry of information as to just a mineral owner with no sophistication, but that doesn't even make sense as to a lessee like you. So those are their three arguments.
I think that's fair. I think when you look at unleased interest in 10A, in 3010, it's used twice. The first time it says unleased, and then it talks about as to any lease with the operator. When you look at 10A3, it doesn't have that modifier. I think, and we discussed this at length in brief, but when you look at the scope of what 10A3 is trying to do, and I think it's important that there's many clauses in 10A3 which kind of are utilizing, I think, the analysis employed in TDX, which I know Judge Higginson, you were on. 10A3 is directed to the operator. It's an operator affirmative obligation. And one of the things in...
And why that the Louisiana court, King v. Stroh, specifically said unleased means unleased, not a lease.
So in King, that really wasn't the issue before the court, and I think King is wrong. It's an intermediary court. It's a Third Circuit decision. It's not a Supreme Court decision, and it certainly isn't binding on
Okay, if you're going to say it's wrong, what Louisiana case has said that a lessee is encompassed with inside 10A3?
I don't. I'm sorry, Your Honor, I didn't
No,
interrupt.
just any case. If you're going to say the only Louisiana case that we would make an eerie guess based on, what's your case that says it's wrong or came out the other way?
I think there's no case specifically holding that, but I think the analysis that was utilized in TDX certainly applies in this case. Unleased interest means unleased in various contexts throughout Title 30. As noted in TDX, the Louisiana legislature probably...
To make an eerie guess, we don't look at our own case law. We look at state case law. And you're saying the one case that's spoken to this, you're just saying is wrong.
Yes, Your Honor, I do. I think it's wrong for a couple of reasons. One, the analysis utilized in that case, Your Honor, it just says unleased means unleased. That's what it means. Well, it didn't go through and do a thorough analysis of what it says, and right above that, it says unleased, and then it has a modifier, right? To where we know we're talking about unleased as to the operator when we're talking about the risk fee. Or, sorry, unleased completely when talking about the risk fee. When you get down to 10A3, when you look at the modifiers, and King didn't go through the analysis properly, in my opinion. It's also a weird fact pattern in that it was primarily a servitude case, and I think that's important. The error is that it believes that a lessee is only entitled to its share of production in kind and not a cash payment. There is a host of cases that have held that's not true. TDX is one of them. Amico is another. When you start partitioning gas, there's options, right? Balancing in kind is absolutely preferred, but balancing in cash is certainly acceptable.
But they're embracing that, citing Taylor, that the seller of oil is a gestor. That's another Louisiana case. Isn't that exactly their language? The unit operator acts as a gestor selling oil.
Yes, Your Honor. Taylor also, I think you have to look at the Taylor line of cases, and there are a lot of Taylor cases that we cited. So you have Taylor versus Wardpecker, Taylor versus Taylor, Taylor versus Smith. But the Taylor line of cases where they use the term gestor, it's inaccurate. As we cited in brief, Your Honor, when you look at what was actually being decided in those cases cited by BPX that utilizes the term negotiorum gestio in the context of an operator force-pulled mineral interest owner relationship, you can see that the issue presented in those cases is the applicable prescriptive period. The court's analysis is accurate. They just inaccurately use the term negotiorum gestio to describe the relationship. When determining what the proper prescriptive period is in those cases, they analyze it saying, okay, look, this is quasi-contractual. It's a personal action subject to a 10-year prescriptive period. They go a step further, which is completely dicta and wholly unnecessary, and use the term negotiorum gestio. There is not one single case in Louisiana which has allowed an operator to deduct costs pursuant to the theory of negotiorum gestio. And that's because it clearly does not apply, Your Honor. When you look at the elements and you look at the purpose behind the concept of negotiorum gestio, it comes out of Roman law. It's to promote altruism. And you look at the comments, and it's clear.
But I guess, I mean, her argument is, you could have taken that oil in kind, because you're sophisticated like they are, you know how to market it, but you decided not to. And therefore, they take it all the way to market, they sell it, and they're agreeing under this quasi-contractual relationship, they've got to pay you the proceeds. But they get to deduct the cost that you otherwise would have paid had you taken it in kind to market it. Why doesn't that make sense?
So as far as Dow is not, just because you're a lessee in a force-pulled unit, Dow is not on the same level as BPX, and it's not even remotely close. To say that we're as sophisticated as BPX is just...
Well, you're not in that asymmetrical situation that the legislature created this very particular protective regime. The mineral owner just sitting there, the mom and dad, they've got oil underneath. They don't know what to do with it. So they get forced in, and there are a lot of protections for them. But you're coming in, you're a lessee, you have a fiduciary duty to them. You sound pretty sophisticated. This is what you do.
Your Honor, I would disagree that the scope of... So when Dow acquired its interest, it was in the 70s, I believe, shallow wells. There's a significant difference between drilling and producing gas at a 4,000-foot level as opposed to what BPX is doing in these Haynesville units where you're going 2 miles below the surface of the earth and doing a 2-mile lateral. The scope of sophistication is significantly different. More importantly, as a lessee, vis-a-vis the operator, there's no relationship. Outside of 3010, 1031, 1032, there's no obligations or contracts between these parties. Often, the operator will come in and try to do, in the past, do a JOA, a joint operating agreement, a joint operating agreement which specifies the rights and obligations between the parties in developing as co-owners, essentially, this unit. However, that's not the case. That did not occur in this case, and there's no record that did occur because it didn't. The same thing for a marketing agreement. BPX did not approach Dow and say, hey, let's negotiate or hammer out a marketing agreement. That's not the case. They applied for and obtained a permit to be the unit operator. They went out and drilled and produced this gas. There is no way Dow can get this information from BPX. It is in the exact same position as the mom and pop scenario that you provided.
Would Dow have said, I want my share in kind?
I guess it is a right that they have to request that. That is correct.
They've got, tragedy of commons problem. They've got the oil underground. They've got to sell it. They want to give you your money. They want to deduct their costs. The statute doesn't speak to it.
I think the statute does speak to it. If you look at 3010 and you go and look at there's 2 places that 3010 specifically, well, it's more than 2, candidly. There's multiple places where 3010 addresses selling production. During the period, and as you heard BPX's counsel just described, this well is not entered into payout. Candidly, probably never will. And I think that's something to consider when you look at these force pull mineral interest owners. Their minerals are being taken, sold, and it's interesting that it never turns a profit, at least for the folks that are force pulled into this unit. But when you look at the scope of what's being required under the statute, they have the right to take Dow's gas and deduct specific enumerated costs. Post-production costs simply isn't one of them. While they're recovering, it's the recovery portion.
1002?
Yes, Your Honor.
That's as to mineral owners.
It is to mineral owners, and it would include.
Those are the people that are in this unique risk category.
Well, no, the risk fee statute the risk fee portion of the statute is separate. During the recovery of cost period, the operator is allowed to take their share of production and recover whatever costs are enumerated under the statute. The risk fee penalty provision comes in separately. It's not in play in this case. The notices weren't provided and all those certain things. But that is a little bit of a different animal when we start talking about risk fee. The importance of the risk fee statute, at least for purposes of this case, is that it defines specifically when the legislature wants to be specific about what it means when it says unleased, and if it means unleased, completely unleased, it knows how to do that. Because in the risk fee statute, that's exactly what it does. And you can contrast that with the language utilized in 3010A3, and it is significantly and markedly different. In EI, it says the provisions of this subparagraph B, which is referring to the risk fee provisions, with respect to the risk charge, shall not apply to any unleased interest not subject to an oil and gas and mineral lease. That's not the language they employed in 3010A3. So the district court was correct in that 3010A3, especially when you look at the other modifiers utilized, and we've briefed it heavily, and I'm happy to go into it if you'd like, but it's clear what 10A3 is trying to address, and that is the situation where BPX produces gas, and I think this is critical, and the unit operator sells or otherwise disposes of such unit production. There's an option here. They don't have to do it. Like we talked about in Amico 1 and Amico 2, and it was talked about in Hunt. The commissioner has the authority to order a partition when a market collapses. If a unit operator does not want to sell gas attributable to any specific owner within its unit, it doesn't have to do that if it's a lessee. It can partition the commissioner for the option to leave that gas in the ground, and there would be an imbalance situation at that point that the commissioner would have to go through the Amico 1 factors. Does it cause a waste? Is anyone adversely affected by the method of accounting? And it could either order an accounting in kind at a later date, or it could order an accounting in cash. But that's up to the commissioner, and that's not where we are in this case. I think it's important to note, Your Honors, and I opened up with talking about the regulatory scheme and the purpose it attempts to achieve. And it's important to note, in State versus Edwards, the Louisiana Supreme Court stated, our Constitution wisely provides for the separation of powers and authorizes the legislature to make public policy determinations of controversial issues. What BPX is asking this court to do is take an inapplicable legal theory of negotiorum gestio and overlay it and essentially subsume 3010, at least for purposes of the lessee. It doesn't apply conceptually, Your Honors, and it doesn't apply under these facts. As we talked about earlier, the concept of negotiorum gestio derives from Roman law to promote altruism. We talk about protection from fire, protections from flood, those types of things. It's also important to notice that under 2297, it says you can deduct all necessary and useful costs. There's two protections specifically built into 3010 for people who do not have any contract with the operator. One is an enumerated list of costs which can be deducted. Post-production cost is not one of them. Any necessary and useful cost absolutely is not one of them. More importantly, Your Honor, and I know we hammered this hard and brief, but it's so critical, the limitation on recovery under 3010 is in rem. And that is critical, because if you apply negotiorum gestio to 3010, you open up every unleased mineral interest owner, not just folks like Dow, but also people like the mom and pop scenario we spoke about earlier, to personal liability. And that's devastating. In this case, from, I believe it was May 21, 2012 to November 2013, post-production costs for this well was $4,153,071. If negotiorum gestio is applied, and under 2297, any necessary and useful expenses can be deducted, you're opening up a significant amount of people in this state to personal liability for a relationship that they never even wanted to be in. One of the essential protections under 3010 is that in rem. As we cited in brief, Jones Energy versus Chesapeake, the court affirmed, look, this is a big deal. This is important that we limit recovery to in rem. We cannot open up personal liability for these forced pulled interest owners. Patently unfair.
Of course, this is a big industry, and this issue would recur, as you're saying, across the state. Do you have any case law that has said the language in Taylor is inaccurate? Or can you point us to any practitioner insights into non-working lessees and the interplay between 3010 and 103?
So I think when you look at, again, I keep going back to TDX. I think that case was excellent in giving a broad overview.
No, but I'm trying to have you focus on state law.
Yes, Your Honor. I think, obviously, when you look at, you're talking about the interplay between 3010.
Well, any authority to support your claim that the comment in Taylor is inaccurate.
The comment in Taylor versus Woodpecker?
That
Sorry.
the unit operator, when they're selling oil, acts as a gestor.
So I think when you look at state law, you look at the Louisiana Supreme Court, while it did cite Taylor for the proposition that the relationship is quasi-contractual and it is subject to a 10-year prescriptive period, one of the things that the court in Wells versus Zadok did not do, and I can't be more emphatic about this, they did not adopt this negotiorum gestio theory. There it is. It was explicitly not followed in that case. When you look at, and we've cited a handful of cases in brief, I think some of the best ones are probably Gulf Coast, Marino versus Spain, and the Clement case, where they do actually perform an analysis of what it requires to recover under negotiorum gestio. They apply the facts, they apply the elements. BPX called these Dow's generic threshold requirements. It's not mine, it's not Dow's, it's the text of the Louisiana Civil Code. So we talk about cases in Louisiana, and I know y'all are all extremely familiar with the civilian principles. We start with the text of the articles themselves. We don't start with case law and those interpretations. To the extent that these cases are wrong, or just conflict with the statutes or the articles, they're just wrong, Your Honor. I see that I am out of time.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. Going to probably hop around a little bit to try and get to some of the points that I'd like to make sure I respond to. The modifier in A3 is a prepositional phrase for which parties are entitled to market. That is not an adjective. That does not describe unleased interest. What we have under A3 and A2 is identical in terms of the analysis and the methodology to be applied by this court as you had in TDX when you were analyzing 103.1 and 103.2. And differently here, we have no reference that was intended to be only unleased as to the operator. We have that in 103.1A. We don't have that here, anywhere in 3010. And so it's very important to understand that an unleased interest is not a person, it is a right. And so when you see the phrase, for which party or parties entitled to market production, that's interjecting who has the right. And the district court ruling here reads out of A3 unleased interest. If a lease exists, there is no unleased interest. And that is consistent with the way the legislature defined unleased interest in 3010 in A2. So I also want to address that you can't have a codal regime apply in part. And it's undisputed, even in the authority cited by Dow, in a Louisiana Supreme Court decision of Childs versus Washington, which he quotes for the idea that it's a comprehensive quasi-contract that's created by the conservation statutes. If you read a little bit further down, the court says, in construing the provisions of the conservation statutes, we must do so in the light of the applicable codal articles. 3010 is not exclusive of codal rights or remedies. The Louisiana Supreme Court has said so in his own case.
Just to be clear, if you're persuasive that 10A3 does not describe a unit operator's relationship with a lessee,
Correct.
you are simultaneously saying that there still is a quasi-contractual regime. Taylor describes it. It will not lead to the parade of horribles that he has said.
Correct. And
You owe them money if you take their oil to market, but
Correct.
you get to deduct your costs. That's your
correct. That is our position.
Is there any
And,
authority beyond the dicta in Taylor for that?
well, I don't believe that the Taylor is dicta for the reason that if, in fact, whether it's negotiorum gestio, mandate, co-ownership, good faith possession, whatever codal regime you come up with to say that this is the one that fits for a lessee, it has a reimbursement right. The code does not set up windfalls.
Does it also have a reporting obligation, even if it doesn't come with a statutory penalty?
Yes, it does. Yes, it does, Your Honor. There are reporting obligations under the code. They're not the same as 103.1 and 2, but there are reporting obligations. And so another point that I'd like to make sure that the court understands on the in rem point, That is only under A2. The right to recoup in rem is only under A2. A3 says nothing about in rem. And so why does that matter? He's saying that there's a parade of horrors that comes that he's going to have to pay $4 million. BPX owns a majority of this unit. It has borne a majority of that $4 million for the post-production costs. So if they ride along our capacity, if they ride along our arrangements, they're benefiting from that. And another point that I want to make sure we understand is that he says that we have a choice to not market for the lessee. If you read the decision that we cited in our case, Amico, Tufts versus Amico, the court said that that would lead to the well being shut in. You can't split unless there have been arrangements and physical separators have been in place. You cannot pull out for everybody else and leave his in the ground. That's what we learned from Amico v. Thompson. And so keep in mind that there is a benefit to him of riding along. And all we're asking for is reasonable and necessary expenses. We're not going to be charging these unwieldy expenses, and the operator is going to have a majority of them. And then finally, the policy of the risk fee statute is to encourage participation. This result does not encourage participation. It encourages people to sit on the sidelines and not participate because they can rely on A3, not take in kind, and then they don't even have to market for their own lessors. Thank you, Your Honors.
Thank you, counsel. The court will take this matter under advisement. This concludes the cases that we have on today's oral argument calendar. We are adjourned.